Policy Exchange has published a new report on the future of this law. Joining us now is Richard Ekins, KC, Head of Policy Exchange's Judicial Power Project. Richard, good afternoon to you, sir.
Good afternoon.
If my history serves me correctly, we're just shy of a month away from the 75th anniversary of the European Convention of Human Rights. I know you're going to tell me I've got that horrendously wrong, but it's in that ballpark, right?
Yeah, it's the 25th anniversary today of the Human Rights Act coming into force.
OK. And in terms of laws, which, as you know as a lawyer, laws are kind of fluid. They move around. There's a labyrinthine world of law that, you know, means that it responds to things, it reacts to things, new precedents are set, etc. But the ECHR seems to be the sort of physics impenetrable thing that just sort of sits there and nothing can ever get beyond it. No one can modify it. If you touch it, you'll turn to stone. Goodness knows what else. That's sort of how we look at this curious part of European legislation.
It's funny, in a way I look at it and see something that is quite changeable, although often in very bad ways. So in fact, if you read the convention, it doesn't say anything about migration or asylum. And beginning in the 1970s, the Strasbourg Court, the European Court of Human Rights, really did start to expand and remake the convention over time, trying to update it as it saw it, to improve it as it saw it. Again, but the problem with that was it was really adding to the convention things that the member states had never agreed.
Yeah.
So it has developed quite significantly over time, but in ways that really the member states shouldn't put up with and shouldn't have put up with.
Yeah, and of course the line that always comes out is, hang on a second, you know, Churchill was, you know, one of the authors of this thing, for goodness sake. If it's good enough for Winston, then it's good enough for us now. And, you know, obviously there's some truth in that, but, you know, you take the
Not
point.
much,
well, I was about to say, you know, it's not as if, you know, he sat there in Downing Street with a big old quill and wrote this thing. It didn't happen like that, but...
Well, he wasn't in government. He wasn't in government when we joined. It was Clement Attlee who was Prime Minister.
So we should blame Clement Attlee then in that respect.
Well, to be fair to Clement Attlee and his colleagues, they were reluctant to join the ECHR. They had some idea that it was out of step with our constitutional tradition and a bit dangerous.
Yeah.
But they also didn't foresee what the court would later do, which really is to expand it beyond recognition. I think they would be horrified by what they saw. And Policy Exchange published a report about a month ago, or 2 months maybe now, precisely on that point, attacking that myth that this somehow is Churchill's baby, and if we reform it or if we leave it, somehow we're dishonouring the great man's memory.
And whether we look at Churchill, whether we look at Attlee, the point that is, I suppose, the spirit of the point that is made is essentially what was written back then can't always apply to today, and as you rightly say, doesn't mention immigration as such. But it's certainly, there's no doubt that it is a law that is being lent on as a mechanism of defence for this area of migration.
Oh, sure. No, it's definitely an enormous practical problem that's arisen. In a way, I'd say it's not the fault, again, of Churchill or Attlee or anyone involved in making the convention in 1950. I mean, there are some important human rights that shouldn't be violated, but human rights law has developed in ways that really are way out of step with what human rights properly are or how they should be understood. And human rights law, as it has been developed, has been turned into a means of blocking all manner of government policies or decisions by Parliament in ways that you know, sovereign states should be pretty worried about, really.
Yeah.
And,
so we could
parliamentary democracy likewise.
So Richard, it can be changed. I mean, even if. I mean,
Sure.
So some people say, well, just get rid of it and, you know, pretty much all the good bits we'll just simulate and bring into domestic law. I don't think anybody has a problem with that. You know, nobody is suggesting we have no human rights. But the idea that it's a 75-year-old ruling or convention that needs to be adhered to is just not really fit for purpose in the 21st century. Is that fair?
Well, as it's been remade by the Strasbourg Court, there are serious problems with it. Yeah. And it's perfectly respectable, as you say, to think, well, it's not working, we should withdraw and we'll do our own thing. And we protected human rights perfectly adequately before we joined the convention,
sure.
Before the convention really became sort of a significant part of our daily life, before the Human Rights Act came into force.
Yeah. And all the other countries around the world, of course, that have their own human rights that aren't connected to this in any shape or form.
Sure. Coming from New Zealand,
well, I was about to say, you would, I don't think New Zealand rely on this convention.
No, indeed. Yet it's still a nice country to live in, notwithstanding. So it's a lot of absurd claims are made here that somehow if we were to leave the convention, we'd be in company with Russia or Belarus. I think that's just preposterous, really.
Yeah. So if Kemi Badenoch stands up in the next couple of days and there's some smart money that says she might do this, says we will leave the convention, obviously all hell will break loose, and there'll be many Conservatives as well as other people who say, you can't do that, you know, you're leaving us open to all sorts of horrors that will be unleashed on individuals and humans, and we'll melt at the mere idea that we are no longer protected by this almost century-old ruling. That's nonsense. She could do it, and she could do it with relative ease, without even allowing for the fact there'll be controversy?
Well, there will be controversy, as you say, of course. No, she certainly could do it if she were in a position to lead the next government. And it'd be a good case for so doing. Our paper, which we published today, really does entertain the options that there are, of which the most comprehensive and most direct, and thus probably the most effective, is to withdraw from the convention. And the thought that somehow that's a sort of a disreputable option is I think, just not true. And there are some points that if she does make that policy announcement, that she, like anyone else taking that position, does need to think about and to have answers for. And we, in our paper, entertain the various objections likely to be made. We've touched on one already, the sort of the suggestion you'll be in company with Belarus or Russia, ridiculous arguments about Northern Ireland and Good Friday are more serious. We published a paper a month ago, though, Policy Exchange, that answered those objections, I think, pretty comprehensively. Mm-hmm. But so any government that intends to withdraw does need to have thought this through carefully. Yeah. But the answers are there. They just need to make sure they can present it intelligently and not assume somehow that if we were to leave the convention, would be giving up on the idea of human rights protection.
100%. Richard, great to have you on. Very thoroughly put to us as well. Thank you, sir. Richard Ekins, KC. He's head of the Policy Exchange's Judicial Power Project. It was their new research that looked into this. They published